Recorded from now. Here we go, just like magic.
Just to say, I won't be always on video during this call. And I think maybe Chanel won't be either. I don't know about other people.
Thanks, Hillary. And the one thing I didn't organise, Tom, are you happy to share the slides?
Yeah.
Great, perfect. We'll just wait another minute or so, and then we'll get underway. And I will look, keep an eye out for any hands up as well, as we go through. I think we might, Tom, we might start. So, as I said in the email, this is just a briefing. We've got a skeleton team running point on this. So we have just pulled out some key facts. We've given you more information in the slides that we intend to talk to. And I fully anticipate that you all have questions that we are just not in a position to answer at this point in time. Joe's just said my camera is doing something funny, so you can't see me, but I'm not quite sure why. I will try to figure that out while I talk. Sorry about that. But we will take any questions that you do have, and we will respond in writing to the whole group of councillors, so you've all got the same answers. And we're just working around understanding what the timeline is going to look like. We just found out yesterday when the submissions close, so we'll work through what that looks like, balancing. We've got staff taking well-deserved leave and things like that. So we will work out a timeline and come back to you with the detail of that. But I will turn my video off and see if I can figure out how to fix it. And Tom, I'll pass over to you. So just in terms of staff, we've got Tom de Pulsemaker, who's our team leader, Freshwater and Land, who will be new to a number of you councillors. We've got Tanner Throb, who's one of the seniors in our team presenting. Sam Walton is another one of our seniors, and Julia Briggs is the same. So they're the four that I think are going to talk you through the slides, and I will be noting down any questions as we go. So Tom, we are in your hands.
Kia ora, councillors. I hope you can see presentation. Is that turning up on your screen now? Yep. Kia ora. Good morning. My name is Tom de Pulsemaker. As Anita said, I'm a team leader. I'll be doing the first part of the presentation, and then I'll hand over to other staff. We've got 3 hours set aside for this presentation, and it is about legislation, so it's pretty dry. And I've been going back and forth as to how I can best kind of ease you into the material. And just kind of take you through the structure. We'll talk about some general themes first. Then we'll dive into the planning bill. That will be part B, but we won't go in too much detail. We'll spend a bit of time on the spatial plan because that's something that is falling within or that is likely to fall within our jurisdiction. But we'll gloss over the land use plans. And then we'll dive into the natural environment bill because that is more relevant to regional council functions as well. As I said before, I just want to kind of ease you into the matter. And I thought a good way to start would be to actually show you the objectives that sit behind the resource management reform. You actually won't find them in the bill. They're kind of buried in the guidance material and the explanatory notes. But they illustrate actually that this is more than just fixing what's wrong with the current Resource Management Act. They actually show that this reform is part of government trying to deliver on some of its strategic priorities, which is stimulating housing and business growth, enabling infrastructure development, and also stimulating the primary sector. So when you're kind of reading the bills and you wonder, like, why have they done this, or why is this not included, or why do they take this approach? It's always good to kind of keep that in mind. That being said, there are a number of things, real issues with the current system. And this slide actually shows or tries to illustrate some of the problems that we've got currently with the Resource Management Act. It's a pyramid, it's a decision-making pyramid, and it shows that a lot of the decisions are actually done right at the bottom, at the local level. And it's a decentralized system where decisions are made on a case-by-case basis. Right at the top, we've got the Resource Management Act, and it's got a purpose, which is to promote sustainable management. But it is actually very unclear what that means. And the RMA tries to promote sustainable management by balancing the four well-beings: economic, social, cultural, and environmental well-being. But that balancing act has been, over the past 3 decades, it has caused a lot of debate, a lot of litigation as well. Governments have tried to resolve that problem by releasing national direction. But the national direction, again, has been released over nearly 2 decades. We've got nearly a dozen pieces of national direction, or NPSs as we call them, but they're all a product of their time. They have a different philosophy, and they try to achieve different outcomes. So they're actually not a coherent package. There's a lot of internal inconsistencies. So the problems that are kind of occurring at the central government level with legislation, the current legislation and national direction, they've been translated, or you'll also see them at the regional and local level. Again, we've got, at that level, we've got a lot of plans, regional plans and district plans. We've got over 100 across the country, but they've all been released at different times. They were developed under different legislation or national direction. So again, they're really very different in terms of the language that they use, the outcomes that they try to achieve. When we look at Otago, we've got 10 different plans. So if you want to develop, or if you want to build a factory, you probably have to look at 5 different plans that are all very different. It's a really complex system to navigate, not just for decision makers and for consent officers, but also for people that just want to do things or that are preparing an application. So the government really wants to change that, and they want to have, move towards a system where most of the decisions are made at the national level, so centralized decision making, and a lot of standardization. So what you'll see in the regional plans will be often prescribed rules or zones that are coming down from the central government level. So this is the system that they want to move towards. The RMA will be replaced with 2 bills or 2 acts, the Planning Bill and the Natural Environment Bill. The government is proposing to release national direction on those, but it will be quite different. Instead of having 10 different national direction documents, we'll have one set of national policy direction under each bill. And as I said before, they will be implemented at the regional and local level. Instead of having 100 plans now, we'll go down to 17 plans, 1 plan for each region, and it will be a combined plan that will have a spatial plan, which will replace current RPS, a number of land use plans or chapters, 1 for each district within the region, and then a natural environment plan, really. So there will be far less plans, but there will also be far less consents because the government wants to have more activities that are permitted as well. So yeah, more standardized processes and fewer consents and fewer plans is the key message here. This slide actually shows the architecture of the new system. It just kind of shows the different components of the new regime and where they sit and how they kind of work together. I'm not going to go into each of those different instruments right now. We'll discuss them in more detail later on in the presentation. Before we actually want to dive into the bills and the other planning instruments, I thought it would be good to take you through the transitioning, because we have to move from the current system to a new system. Really, the transitioning really started about half a year ago. In August, the government made an amendment to the current RMA, and people refer to that as the plan stop. So basically, that amendment changed the act, and it basically required all regional councils and district councils to stop working on their current RMA plans. That was a first step. Last week, the planning bill and the natural environment bill were introduced. We're working our way through it, and we've got until the Friday, the 13th of February, to write submissions. That's when the submission period stops. The general expectation is that those bills will come into law around the middle of the year. It's important, I think, to kind of stress that the bills themselves, or the acts, they're more like vessels. They're frameworks. They don't contain a lot of detail, and a lot of the detail that forms part of the new regime will be included in national direction that will be released later on, so after the bills come into law. There's a bit of conflicting messaging. Most of the time, what we notice is that there's a general expectation that there will be two sets of national direction that will be released, but some sources talk about a third suite of national instruments that will be released around 2028. The release of the first package, or the first suite of national direction, that is planned for late 2026, and that should be in time to inform the development of the regional spatial plans. So that package of national direction will contain things like standardized overlays and standardized maps, and it will contain a lot of the policy direction that is needed and that needs to be incorporated into those regional spatial plans. As part of that first package, the government will also release environmental limits for human health. The second package of national instruments is planned to be released almost a year later, towards the middle or late 2027. And that package will inform the development of the land use and the natural environment plans. So you'll see more content there that will help us and district councils to build those plans. They will also contain methodologies for developing environmental limits for ecosystem health, which is something that regional councils will have to do and include in their natural environment plans. The third suite, if it happens, is likely to contain more complex matters like national direction on how to deal with allocation. So this is a timeline. As you move further away from the present, things are a little bit more unclear, but there are some things that are certain. Officially, the transition period will start 1 month after the acts come into law. And from that moment on, we'll have 15 months to develop regional spatial plans. After 15 months, each region has to notify a spatial plan. 6 months after the notification of a spatial plan, decisions need to be made on those spatial plans. So we've got 6 months basically to go through a submission process, undertake hearings, and for a panel to make recommendations on those submissions. Then we've got another 9 months after decisions are made on the spatial plan to develop natural use and a land use, natural environment and land use plans. And then again, we've got 1 year to move from notification to decisions on those plans. So all the submissions and hearings process needs to be undertaken within 1 year. All in all, the general expectation is that the transition will take about 3.5 years. That seems generous, but whether it's achievable kind of depends on a number of things. One, it's really crucial that at a local level or regional level that we have visibility on the national direction in time to inform those plans. Secondly, it also relies on there not being any appeals on spatial plans particularly, because if you have an appeal on a spatial plan, you're kind of in a limbo when it comes to developing your land use and natural environment plans, because they need to be consistent, and your natural environment plans and land use plans, they actually need to implement what's in your spatial plan. Also 1 year to go from notification to decisions on land use and natural environment plans is quite ambitious. You have to remember that combined plan will basically be the sum of nearly 10 district and regional plans. So there will be quite a lot of submissions on various topics and various aspects of them. Another key point I think to make is that during the transition, the RMA will continue to exist. The RMA will be repealed at the end of the transition period, and that will happen after all the combined plans in their entirety, so the land use plans and the natural environment plans as well, after they have been notified and have legal effect. So at that point, the minister will place an order in council, and he'll announce that the transition period has ended, and he will repeal the Resource Management Act. So what's there to do during the transition? But first and foremost, as I said before, the RMA continues to exist. So councils, regional councils, or territorial authorities, they need to continue to administer and enforce the existing RMA plans and the consents. When the transition starts, we also need to start working with our TAs, with the TAs in the region, to develop that new regional planning framework. And the first step of that will be to develop that spatial plan. And it's also important that we start talking to our neighboring regions while they are developing their own combined plans, because we need to make sure that we're aligned when it comes to cross-boundary matters. So that's an overview basically of the transition. If you're happy with that, I might actually now start to kind of talk a little bit more about the instruments themselves that are being released. I'm not going to take you through the bills in much detail, but I thought it would be good to kind of start with 2 slides that show the purpose of planning bill and the goals of the planning bills, and then afterwards show the purpose of and the goals of the Natural Environment Bill. So the purpose of this bill is to establish a framework for planning and regulating use, development, and enjoyment of land. And if you're familiar with the RMA, you'll see that that purpose statement is quite different from the RMA purpose statement, which is simply to promote sustainable management. The goals themselves, they're quite different from the other aspects of Part 2, the principles of the Act. They're a lot more specific, and they have a focus that is also more towards development and enabling economic growth and the development of land. The goals, because they're more specific and in a sense more narrower, they also restrict the activities and the effects that can be managed under the Planning Bill compared to the Resource Management Act. So when it comes to the effects that can be managed, the effects are more focused on making sure that we don't end up with incompatible land uses. They're more focused on dealing with reverse sensitivity as well. Within this bill, there is very little focus on managing environmental effects and then focus on environmental protection, because that is being done through the Natural Environment Bill, so not this bill. Moving on to the Natural Environment Bill, again, purpose statement, which is to establish a framework for use and protection and enhancement of the natural environment, and some very specific goals that are also narrower in terms of their focus than the RMA. So again, things that don't relate to the goals are not supposed to be managed under this legislative framework. There's two things that kind of stand out. One is environmental limits. That has been introduced previously through national policy statements, but it has never been incorporated at this level, at primary legislation, and it signals a departure from that kind of balancing of the four well-beings towards an approach where we actually have environmental bottom lines or bottom lines around human health. So that's a significant difference. Another thing that signals a departure in management approach is achieve no net loss of indigenous biodiversity. And I want to draw your attention to the no net loss, because the RMA was very much focused on avoiding, mitigating, and remedying environmental effects. The no net loss signals actually that under the new legislative framework, there will be other tools in the toolbox like offsetting and compensation, but we'll talk about that a little bit more later on. One thing that you might have noticed as well is that between the goals, there's no real hierarchy. And that means that when it comes to implementing frameworks, we're supposed to deliver on all of the goals, really. Under the bills sit national instruments. And the purpose of those national instruments is basically to direct which activities and effects need to be managed and how that management needs to occur. And they're also going to direct us on how the frameworks need to be implemented. There's basically two types of national instruments. There's national policy direction and national standards. So together they will provide centralized direction on how we have to develop our policies, on how we have to regulate activities, and on how we have to undertake processes. So if we want, they will basically direct us as to how we have to develop our plans. The national instruments, they must be implemented. There's no leeway unless the instruments themselves say that at a local or regional level, we have options, or if they allow us to come up with bespoke solutions. They can apply to the entire country, But in some instances, aspects of national instruments may be tailored or provide direction for one region only, or one district, or one part of the country, really. So the first type is the national policy direction. And I mentioned it before, instead of having all these different NPSs, we'll have one national policy direction document under each act. And that's anticipated to be quite a concise document. 20 to 30 pages max is what I've heard. So basically, what those documents will do is they try to particularize the goals, which means they direct as to how the goals must be realized by regional councils or by district councils on the ground. They can also restrict as to how the goals must be achieved. So they can say you cannot achieve the goal by doing this or that. So they'll basically include, they can include objectives or other content that we need to put in our plans. The national policy direction instruments themselves, they're likely to contain objectives, policies, or directives. They're unlikely to contain specific rules. The policy direction instruments as well, they are supposed to deal with any potential conflict between the goals. Like I said before, there's no real hierarchy. It's not inconceivable that there will be tension between delivering on all those different goals at the same time. So national policy direction will include direction for us to say how we're going to deal with those conflicts. The national standards are different. They're much more specific. As I said, national policy direction is a bit like NPSs. National standards, you can think of them as being the successor to national environmental standards or national planning standards. So they will make sure that there is regulatory, administrative, and procedural consistency. And what I mean with that is regulatory consistency means that there will be a standardized way of dealing with certain activities. Administrative consistency means that basically those standards are going to prescribe how we have to develop our plans, how we have to monitor them, monitor their effectiveness and efficiency, how we have to publish them. And procedural consistency means that there needs to be consistency in terms of how we undertake plan development. That's basically the main points about that. And then if we move down one level, we have at the local level, we've got those combined plans. Sam and Julia later on, they'll talk a little bit more in detail about the content of spatial plans, land use plans, and natural environment plans. But here's a bit of a high level summary, really. So there will be one combined plan for each region at all times. They'll be standardized in terms of their format and their structure. And that is something that the government previously tried to do with the current plans through the national planning standards. There will also be e-plans, but the main difference is that most e-plans now, they're published on the website of that local authority. For the combined plans, the government is developing one portal for the entire nation, and all the plans will be published there. As I said before, they'll include a regional spatial plan and a land use and natural environment plan. Those land use and natural environment plans, they will be made up from the same ingredients, really, that we have right now. So they'll include objectives, they'll include policies and rules, but they'll also include a regulatory relief framework. And that is something new. And I'll talk about that later on. They can also include non-regulatory methods, but there's no obligation to do that. And finally, something that is entirely new are the procedural principles. Each bill contains a set of procedural principles, and those principles are consistent across both bills. I'm not going to read them out loud, but they're actually really common sense things, and they encourage us, or actually they require us to undertake good practices. You can't really argue with the fact that our plans need to have need to be written in a language that everybody can understand. We have to be cost effective, and they need to be based on sufficient information. So common sense matters. The only thing is that it's a lot of these concepts are currently not defined, and it's likely going to be a matter of debate as well, or a matter of opinion as to whether we have enough information or not, or whether we're enabling enough. So the feedback that I've heard so far is that there could be quite a bit of litigation actually around those principles. So that was a bit of an overview, basically, of the transition and the different instruments that are being introduced through this reform. I'm now going to hand over to Tenneth, who will give you an overview of the different roles and the responsibilities of central government, regional council, district council, and also Environment Court. So she'll highlight what changes are coming in those areas.
Thanks, Tom. Can everybody hear me okay? Great. So in terms of governance roles and responsibilities under the bills, central government has a broader and more active role in shaping and overseeing the new system. It will develop national instruments, as Tom has already outlined. It will specify limits for human health, and it can specify minimum ecosystem health limits. And central government will also set methodologies for regional councils to follow when setting ecosystem health limits through their national natural environment plans. Central government will also monitor system performance, and we have a slide on that coming up. And it also will appoint members to the Spatial Plan Committee that will be responsible for developing spatial plans and can make direction on the composition of independent hearing panels. Can we move on to the next? Oh, thanks, Tom. So under the Natural Environment Bill, regional councils have a general responsibility to enable and regulate the use, protection, and enhancement of the natural environment within their regions. And regional councils will contribute to the development of spatial plans through that Spatial Plan Committee. It will make and maintain and monitor the implementation effectiveness of the natural environment plans. It'll regional councils will set ecological health limits in line with central government methodology. And regional councils also are the permit authority. So natural environment permits, which have previously been called consents, are now called permits in the new system. And they'll also undertake compliance and enforcement activities. And as Tom has also mentioned, regional councils must compile and publish reviews of the results of the monitoring undertaken no less than every 5 years. So in terms of territorial authorities under the planning bill, they have a general responsibility to enable and regulate the use and development of land within its district, including subdivision. They are the consent authorities for planning consents, and like regional councils, they also contribute to the development of spatial plan for the region. And they also monitor the implementation and effectiveness of the land use plan for their respective districts. And there's a requirement to compile and publish the monitoring results no less than every 5 years, like regional councils. So the planning bill establishes a new planning tribunal to resolve certain lower level disputes between system users and councils, and this will usually happen on the papers unless a hearing is considered necessary. The key functions will be reviewing administrative decisions made in the processing of consents and permits. And the tribunal can confirm, modify, quash decisions, or send them back for reconsideration. The tribunal will not have a role in hearing appeals on plans or designations, notified consents and permits where there are third-party submitters, and it will not deal with enforcement matters. These will remain with the Environment Court. So the Environment Court continues its current functions, hearing appeals, and its compliance and enforcement functions, and the Environmental Protection Authority may perform compliance and enforcement functions when necessary. It can also assist local authorities with enforcement action or intervene in the enforcement action of local authorities or take enforcement action against regional councils. So in the new system, territorial authorities, the Minister and the Chief Executive of the Ministry for the Environment all have system monitoring responsibilities. The Minister is responsible for monitoring the performance of the system, the implementation and effect of the bills, and the regulations that sit under it, the relationship between the functions, powers and duties of central government, and any significant land use matter as the Minister sees fit. The Minister also has quite broad powers to intervene, including directing regional councils and territorial authorities to prepare a plan change or variation, and the Minister can investigate and make recommendations of the performance of local authorities or any of its functions. It can appoint one or more persons to exercise or perform all the functions of a local authority or direct a local authority to achieve an outcome specified by the Minister. The Ministry for the Environment must maintain regular strategic oversight of the system by improving understanding of the extent that the legislative and system outcomes are achieved, enabling continuous evidence-based improvements to the operation of the system, supporting improvement in the way the legislation is implemented, and establishing a process to identify and respond to emerging system-wide issues, including national direction outcomes. Regional councils are responsible for monitoring the efficiency and effectiveness of limits, of the processes used by councils, the exercise of permits, and the exercise of protected customary rights in the region, and the implementation and effectiveness of any water conservation orders. Territorial authorities monitoring must consider the efficiency and effectiveness of rules or other methods, the performance of any functions performed under the bill, the efficiencies of the processes, and the exercise of consents. And earlier this week, there was an announcement about a new ministry. The new ministry will bring together the Ministry for the Environment, the Ministry of Housing and Urban Development, the Ministry of Transport, and the local government functions of the Department of Internal Affairs into one large agency. So each of the bills have a clause that recognises the Crown's responsibilities in relation to the Treaty of Waitangi. There is a goal in each bill that provides for Māori interests through Māori participation in the development of national instruments, spatial planning, and land use plans and natural environment plans, the identification and protection of sites of significance to Māori, including wahi tapu, water bodies, or sites in or on the coastal marine area, and enabling the development and protection of identified Māori land. And coming back to your question, Kate, that is obviously quite broad, and the detail of how that will be implemented and achieved will be in the policies and objectives set through national policy direction and national standards, which councils will have to implement. So how that will be, well, the devil's in the detail essentially, and that's still to come. There are requirements to notify and consult iwi authorities in the development of national instruments and regional combined plans, and the existing treaty settlements and other agreements will be upheld under the new bills.
Thank you, Tyneth. Another big change that is introduced through these reforms is the way in which activities are managed. Under the RMA, we've got 6 different activity categories, and under the new system that will be reduced to 4 different categories. So we'll still have permitted activities, we'll have restricted discretionary activities, or discretionary activities and prohibited activities, but there will be no longer controlled activities, which are activities that require a permit or consent, but we have to give the consent, but we can set some conditions, or non-complying activities, which is a really complex consenting process. So in terms of the permitted activities, those are obviously activities that don't require resource consent or a permit, as they're now called. But one important change is that under the new system, they may need to be registered with the territorial authorities, which is a good thing, because you don't want to consent for everything, but you want to know what's happening, what activities are being undertaken. It's also anticipated that more activities will be permitted under the new system as well, because the threshold of considering effects will change as well, and I'll talk a little bit about that more later on. But basically, permitted activities are activities that activities that you'll expect to see in a certain zone or in a certain area. They're activities whose effects are well understood and can be easily managed through permitted activity conditions. Restricted discretionary activities are activities that require a permit, and councils can either grant the permit or decline it. But on the whole, there's still activities that you'll expect to see within an environment or within a zone. But some of the effects require management through tailored consent conditions. And then there's a third category, discretionary activities. Again, they require a permit. Those will be activities that are inconsistent with what's stated in the spatial plan, with the zoning of the spatial plan. They may be inappropriate or may not be anticipated, and they're generally activities where we don't really understand the effects, or where the effects are a little bit uncertain, and so they will require a full assessment. Prohibited activities also, they will continue to exist, and in those cases, people cannot apply for a consent. As I said before, there's some changes to the way the new system will manage effects. The current RMA has a provision really that requires any person undertaking functions under the Act to avoid, mitigate, or remedy those adverse effects. There's a similar provision in the new bills, but it's slightly differently framed. It says persons performing functions under the Act must consider how adverse effects are to be avoided, minimized, or remedied where practicable, and or adverse effects are to be offset or compensated where appropriate. And so there's 3 changes. One is pretty subtle. It's a change from mitigating to minimizing. But there's also, that's the second change, the addition of where practicable, which is something that is actually a concept that's already introduced in our RPS framework. And then there is also now a new tool, which is providing for offsetting or compensation. Again, It's not entirely new. For example, that is already included in the current NPS for freshwater, but it was never included in the RMA. It's a very complex thing. I expect that a lot of the detail, like where we can use those tools for what kind of activities, that will come true in the national direction. The current bills only set up the framework, and they only signal really that this is something that we'll be able to do, or that applicants will be able to do. Another change is that less than minor adverse effects cannot be considered, but there is still the need to consider cumulative effects. And cumulative effects are basically activities, 2 or more activities that have a greater than less than minor effect. So those types of activities we can still manage. However, a big change is that some effects are out of scope. They can no longer be considered, and some of those effects relate to natural character, visual amenity, viewpoints, and landscape. However, those changes mostly impact really on territorial authority functions, because amenity is not something, or visual amenity is not really something that regional councils manage. And then I want to talk a little bit about the regulatory relief framework, because that is entirely new. And it's been already the source of much debate, and it's drawn a lot of attention, really. What is regulatory relief? It basically means that if we want to include a rule, or we're proposing to set a rule that sets protections for certain values that are associated with a property, and that place restrictions on how that property can be used, then we have to proactively contact the landowners to offer relief. The bills actually introduce 2 types of relief. There's mandatory relief and there's voluntary relief. I'll talk a little bit about voluntary relief later, but I'll start off with the regulatory relief. So basically, when we've got a proposed plan and it imposes a rule that significantly impacts a landowner's reasonable use of that land, then we have to provide relief. It's going to be, a lot of the concepts within that phrase aren't really defined. It will be interesting to see what means significant impact, and what is reasonable use. And it would be good, again, to have a little bit of clarity around that. Relief can only be provided under certain circumstances as well. So the rules that trigger regulatory relief are rules that are limited to heritage, outstanding landscapes, sites of significance to Maori, areas of high natural character in the coastal environment, wetlands, lakes, or rivers, significant natural areas, and terrestrial indigenous biodiversity. So you can only apply for relief, or you're only eligible for relief, if the protection relates to those things. Again, most of the rules that trigger relief fall within the jurisdiction of territorial authorities. However, under the new Natural Environment Bill, indigenous biodiversity SNAs will come within the realm of what regional councils manage. We also manage sites of significance to Maori, so it does have repercussions for us. So where an authority is proposing rules that set those types of protections, there's a number of things that a council must do. First of all, we need to provide justification. So we need to come up with evidence, good evidence and data that justifies those protections on the properties that are impacted by it. We also have to develop a framework for providing relief, and that framework needs to be included in the plan. And the framework basically sets out what type of relief we are providing and how much relief we should provide given certain impacts on a property. And a few other procedural matters as well need to be spelled out in that framework. We don't just have to put it in the plan, we actually have to implement it as well. And that means that councils are required to identify properties that are impacted, and they have to inform the landowners of the fact that they're eligible for relief. The relief itself can be provided in a number of different forms. It could be a payout, so monetary relief. It could be rate reductions, fee reductions. It could be extra development rights or land swaps. Under the current system, the appeal rights will be restricted, but it's important to say that these regulatory relief frameworks are open to appeal, so people can appeal those frameworks during the hearings, submissions and the hearings process. So again, there's an expectation that this will be triggering quite a few appeals, and it will be something that, could trigger litigation. I mentioned earlier on that the bills also provide for voluntary relief. And basically what is meant by that is that the bill allows you to set methods in your plan, voluntary methods that encourage people to do certain things or undertake certain activities that contribute to achieving the goals of the Act. And so when that happens, councils can provide an incentive or relief to landowner who's undertaking that activity. And now we've talked a lot about plan making and plan development. Just want to hand over now to Alex King, who's the manager in consents, and she'll talk you through the implications of the new regime for consenting or permitting.
I just see Alan's hand up there.
Yeah, thank you. Look, if I can just go back to something that Tanith brought up, where Tanith ran through the responsibilities of different levels, including regional councils and territorial authorities. So do these bills specify those specific responsibilities, regional councils, territorial authorities? I'm just asking in view of the other sort of reorganisation plans around local government. Are those things specified for those different councils in the bills?
Yes, they specifically refer to regional councils.
Which presumably does raise some further questions should there be that reorganisation of local government and maybe there are no regional councils. Is there any information on a further transition required there, or are we silent on that?
No, as introduced, the bills are silent on that.
Right.
Yes.
Okay, there's another complication to think about. There had also been some earlier suggestion or perhaps speculation before the bills were introduced that the sort of consenting responsibilities might be handed over to some national body. Now that has disappeared, that idea, has it?
I think it was a suggestion that the compliance and enforcement functions might be handed to a central agency, and I understand those decisions are still to be made.
And the bills specify that the compliance functions still sit with the appropriate councils.
Okay.
So that's another complicating factor.
Yeah, okay, but for the moment, they're not moving, no suggestion in here of moving to those national bodies. Thank you, that's good. That just get clarification on that, thanks.
Thanks, Helen. So the new system keeps a similar consent process to the RMA, but with a narrow focus and changes to how we can consider effects, as per Tom's slides earlier. Another interesting part of the legislation is around conditions that require positive effects or those for offsetting and compensation must now be agreed by the applicant. This is a current practice of our internal consents teams to send draft conditions out to applicants for agreement prior to any decisions being made. Another change is that notification thresholds also tighten. Limited notification is similar to our current test for public notification under the RMA, and the new public notification is only for significant effects where affected persons can't be identified. And then further to that, only qualifying regional residents or affected persons can submit on those applications. And then in terms of the transition period between the RMA and these new bills, there is a Duration of Consents Amendment Act, which extends all consents expiring prior to the 31st of December 27 to that date. For us, we've looked into this, and that's around 250 consents that wouldn't come in to be replaced over the next 2 years. The only exception are water permits and consents to discharge to water or land where contaminants may enter water, which already have a 35-year consent term, and these can't get any further extensions. So we also have the Otago specific legislation for an additional 5 years for any consents that were water permits under the Plan Change 7 provisions. So those permits will continue to have their expiry dates extended under the existing Otago legislation, and all conditions will remain the same. We've begun reissuing these consents based on when they expire, so the sooner ones are being replaced or extended as we speak. And so from mid-2026, we enter the new transition period. New consents are still processed under the RMA with some adjustments, and existing consents that would expire within 2 years of the system going live, they're looking to extend again in the future. As we mentioned, both compliance and enforcement remain unchanged under the RMA through this transition period, and they are mentioned in those new bills as being something under regional councils, so there is more to come in that space. And then from around 2029 onwards, once the regional combined plans are notified, the new system becomes operational, and ORC continues as the permit and consent authority under that new framework.
And we've just got a question from Kate. Alex.
Thank you.
Sorry, Alex, can you just go back to the previous slide?
Sure. Well, whoever's running the show.
Yeah, so the public, your second last bullet point there, public notification only if effects are significant and there are no affected persons or there are no affected persons consenting.
That can be identified, yeah.
No, I get the second part, or all affected persons cannot be identified. I don't get the first part. And there are no affected persons.
I think it's more around that we can't identify who they are, or their significant effects that don't necessarily connect directly to an affected person, which is slightly different to the tests we have now in the RMA. Yeah.
Okay. Sorry, I'm still struggling with that sentence, so I will go back and reread it. So I thought I presumed that was where people weren't consenting as affected people, but that's not necessarily the case.
No, and I can come back to you specifically on that if that's helpful.
Well, so yeah, and just that other point is that to be an affected person, you have to be basically resident virtually. You can't. I mean, we've all heard Michael going on about sustainable terrace. I'm not going into the detail and truth of that. I'm meaning that presumably that would limit the number of people who could submit.
Yeah, you can only submit on the region. You have to be a resident of the region. Yeah.
Okay. Thank you.
No problem. Thanks.
You finished, Alex? Yeah. Okay. We've gone through like I think the highlights of the reform. As I said at the start, we've put some time aside and we made a few slides that actually dive into the detail a bit more of the planning bill and the natural environment bill. And we'll start off with the planning bill, and I might hand over now to Julia.
Thanks, Tom. Everyone can hear me okay? Perfect. So yeah, these are just a few slides about the planning bill and the regional spatial plan and land use plans that it establishes. So this slide just covers an overview of the main elements of the planning bill. So I think Tom previously mentioned section 11 sets out the core goals of the bill. And for the planning bill, there's an emphasis on enabling economic growth and development of land, with the environmental protection primarily covered under the Natural Environment Bill. So the planning bill also establishes the process for national instruments to be developed to provide centralised direction for local plans on matters such as housing and infrastructure. It also establishes the requirement for a regional combined plan, which will integrate a regional spatial plan chapter, a regional environment plan chapter, and a land use chapter for each territorial authority. And it also governs land use planning consents that will be administered by territorial authorities. Next slide. This is a diagram that MFE have produced to show where the regional combined plans sit in the wider system. So you can see them there highlighted in yellow. The regional combined plan, it aims to bring together the regional spatial plan, land use plans, and natural environment planning into one plan. And the idea of this is to help make access easier to the plans for the public, so they can go to one place and see all the plans for the region. Next slide, thank you. Looking at the regional spatial plan component, that's established under the planning bill. Each region is required to have a regional spatial plan chapter for 30 years of growth, and it will identify areas such as areas for growth, infrastructure corridors, and areas that require environmental protection. The spatial plan would have to implement national instruments, both from the Planning Act and National Environment Act requirements. And one of the goals is to help set the strategic direction at a regional level to support integration of development and investment planning. And the regional spatial plan will be prepared by a spatial plan committee, and that is made up of all local authorities in a region, so regional and territorial authorities, and there's an opportunity for central government to appoint a member to that spatial planning committee if they choose to. Next slide. So then just looking at the land use plan, and that is also established by the planning bill. So each district is required to produce a land use plan or a chapter of the land use plan for the regional combined plan. And these chapters replace the current district plans that we have. So again, the land use chapters must implement national instruments and the regional spatial plan. There is an exception to this if there's a significant change in circumstances since regional spatial plans are produced, then it doesn't have to. They will include, the land plans will include standardized provisions from the national instruments and use like standardized zones, overlays and rules where they require this, and can include bespoke provisions where the national instruments allow this to happen. So the land use plans will manage things like urban form and growth, subdivision, land use, natural hazards at the local level, contaminated land and heritage. And they must be reviewed every 10 years. And those are the two plans that are established under the planning bill. And I think in the next section, Sam's going to lead you through the regional natural environment plan part.
Kia ora, thanks, Julia. Can everyone hear me okay? So I'm going to talk on some of the main elements of the Natural Environment Bill. And so, as we've already heard today, the bill establishes goals to be achieved in the natural environment. It sets out the requirements for setting environmental limits and natural environment plans. The national instruments, they will provide the detail and the direction for natural environment matters. And as we've also heard, the bill establishes a new permitting framework for activities affecting natural resources. So consents authorised by the regional councils will now be called natural resource permits. Next slide, please. So this slide shows where regional natural environment plans fit within the system, as you can see by the highlighted box down in the right corner there. And so each region must have one plan, and the role of these plans is to enable and regulate the use, protection, and enhancement of natural resources within national limits. So these regional natural environment plans, they'll include standardised national provisions, limits, and they can also have bespoke rules where this is allowed. And so these plans, they must be reviewed every 10 years. And they're the primary regional planning instrument for managing freshwater, Indigenous biodiversity, air, the coast, and natural hazards. So this slide highlights some of the key points relating to environmental limits, managing freshwater and natural hazards. So environmental limits are to be set for air, water, which includes freshwater, geothermal, and coastal water, for land, soil, and Indigenous biodiversity. An important note here is that limits for air can only be set by regional councils if it is directed by national standards set by central government. And the methodologies for setting these limits are to be set by national standards that will come through national instruments once the system is operating. So limits are set to protect ecosystem health and human health. Human health limits, they will be set by central government. So some of the tools that the bill establishes for the use and management of natural resources that are subject to environmental limits will include caps on resource use and action plans. And so any decision making under the National Environment Act, when it comes in force, must give particular consideration to the effects on natural resources and natural hazards when assessing any activities. Some of the freshwater management tools that are included in the bill are largely carried over from the RMA. So water conservation orders are carried through, and so existing water conservation orders, they are retained. And for new water conservation orders, the criteria is slightly narrowed. The bill also includes freshwater farm plans for managing diffuse effects and farm scale compliance. And this largely takes the same approach under the RMA, and regional councils retain that responsibility to enforce, monitor, and keep records in regards to these plans. Next slide, please. So this slide is summarising some of the key points regarding the allocation of natural resources. So like the RMA, regional councils are responsible for allocating natural resources, and this will be through the natural environment plans. And some of the resources that are included here are the taking of water, discharges to air or water, the occupation of space, in the coast, as well as sand, shingle, shells in the beds of rivers and lakes, and in the coastal marine area as well. So natural resources, they can be allocated through permitted activities and through permits that are granted in the order in which they are lodged with the council. So this is very much the same as the first in, first serve approach under the RMA. The key difference here in terms of allocation is that the bill introduces a suite of new allocation methods. So this includes auctions, tenders, and comparative consenting. However, these methods cannot be used until they're introduced through national instruments. And these national instruments, they will set out the requirements of how to use these tools and the process for implementing them in the future. So just a quick summary in this slide on the key points relating to compliance and enforcement under the bill. So the bill is essentially carrying over the compliance and enforcement tools in the RMA. So this includes abatement notices, infringement offences, prosecutions, and enforcement orders. What the bill does do, though, is it adds a whole new suite of new tools that are much more focused on accountability for non-compliance and a more effective deterrence. These tools build on the polluter pays principle. Just as a way of an example, some of these tools include financial assurances. So this is where a bond or insurance can be set as a condition of a consent for specific high-risk activities. There are also a tool that's an adverse publicity order. And so this is essentially a naming and shaming penalty, which would make people reveal their failures to the public or to the industry to ensure accountability and broader awareness of their non-compliance. And so another part of compliance and enforcement is that it requires council to prepare compliance and enforcement strategy and to publish this information around enforcement activities. Next slide, please. So some of the key changes in regards to compliance and enforcement are really the bill contains much stronger tools available for compliance and enforcement and a much more emphasis on standardization of rules and permitted activities. And so this may require more monitoring of compliance and enforcement. Thanks. I think that's all there, Tom.
Thank you, Sam. So I'm looking at the time and it's 11:15, and basically we've taken you through the entire slide package except for two summary slides at the end. One that kind of gives a snapshot of the key changes. Basically, the RMA is replaced by two bills. There's a new framework. We're going from multiple plans per region to one combined plan. Stronger national direction. The regulatory relief as well is a big change. There will be fewer consents overall and more permitted activities. And in terms of our role, we still have an important role in plan making and in, I was going to say consenting, but in our case, it's permitting. But I think there is a shift though towards more implementation, and that basically the influence of central government in especially plan making processes is becoming stronger as well.
Neil, do you have a question? Councillor Gillespie?
I do, but I was preempting when I was going to ask it, so I'll wait a bit longer and put my hand back up. Not quite ready, sorry.
No, that's okay.
There are some implications, and I've listed the key ones here, and they're very high-level implications. Like I said before, we're actually still working through the detail of the new bill, so we don't want to preempt things, but I think the main implications for us are we're looking at a multi-year transition program, really, and that's going to have an impact on our long-term processes and our work programming to make sure that we're actually adequately geared up to do that transition program. And there will be a dual system as well, where we're kind of basically still have to deal with the RMA while starting to implement the new framework, which adds a degree of complexity, I guess, to our functions and our roles. But that was basically it. I'm sorry if I kind of went through the presentation without noticing the questions or the hands up, but it was a bit hard with the all the screens being filled with PowerPoints, etc. So
we've addressed the questions that have been asked in the chat already, Tom, and
yeah,
a couple of notes to loop back on, and then just Councillor Gillespie, Neil, if you've got a question.
Yeah, thanks, Tom. Just in that sort of second last slide, the last bullet point was local authorities remain key. And I guess my question is have we got a definition of local authorities? What is that going to be going forward? Because the term we use, it sort of sometimes just talks about district, sometimes talks about regional, sometimes talks about both. I'm interested to sort of say, in this, with what with what's happening, where does that fit the term local authorities? What does it actually mean these days? Or don't we know?
Within this context, what I meant with local authorities, that it's written on the slide, means both regional councils and district councils or city councils.
Cool.
Like Kenneth kind of said, basically the bills, they're written without taking into account the proposal for local government reform. But if you look at the bills, there's not a lot of change actually in terms of our functions. The key one would be that around natural hazards management, there's a clear split whereby we manage natural hazards when it's related to natural resource management, and district councils will manage natural hazards when it comes to impacts on settlements or on people, and then the move from managing indigenous biodiversity or terrestrial indigenous biodiversity and SNAs, that will also come into our basket. Sorry, I think
no, that clears it up pretty well, thank you. And it's what I had assumed from what you'd said during the presentation. That's where my mind had got to. So you just confirmed that, saying, hey, there's some other stuff happening out there. But no, thank you for that.
Thanks, Neil. And then Kate, Councillor Wilson.
Thank you. It appears to me that, and it's more a technical legal question, but the language in this version compared to the previous legislation seems to be more, there's less change in that a lot of the terms will potentially stay the same and minimise the litigation. Would that be a fair comment or not? And that the last legislation seemed to have a whole lot of different changes that would have made case law problematic and set up for an ongoing legal, as lawyers like, and I can say that from a bias point, challenging the meaning of the law, whereas this seems to be a lot more, the language seems to be more consistent with and potentially the case law will carry on.
Yeah, so we'll, when we have the workshops with you, we'll drill into that a little bit more. I've only read 2/3 of the natural environment bill, and I haven't picked up the planning bill at all. I would say the opposite. There's
would you? Okay.
Whole lot of words that have been introduced that we don't understand what they mean. Alex pointed to the change in effects thresholds. terms like two human generations. There's the introduction of particular words and clauses that are new, like the insertion of the word people in clauses. So there's quite a bit, but we'll try to talk you through that at the workshop. And there is also quite a bit that's carried through. So it's probably
Yeah.
the same on balance, I would say.
Okay, no, that's cool.
Change different things.
And it may be that the slides were worded in such a way that we understood them and therefore comfortable language. So sorry, thank you.
But we'll try to highlight that when we do the workshops. Any other questions from any other councillors? We've gone through that at a really good pace, but I appreciate that it's high level. We've also enabled some further links if you want to dive in over the Christmas and New Year period, tuck up under a tree and have a read. Then it is interesting stuff. So I'd encourage you all to do that. And we will come back to you with a timeline for what January/February, the first sort of 6 weeks of the year, will look like in terms of workshops and preparing that submission. But that was all that we were going to share with you today. We're happy to give you back 90 minutes, and I'm sure the team will be happy to have 90 minutes back as well. Looks like no more questions. If you do have questions over the break or you think of anything, just flick an email through to me and I'll pick them up on the 5th when I'm back. As I said, we will be back in touch with you before Wednesday next week, just with what the timeline looks like. But I think it's been so well presented that there's no more questions. So thanks, team, for doing that. Richard, is there anything you need to add?
No, not from me. There was just thanks to the team. There's a huge pile of work in a short amount of time, even just to get the summary out. But I think it was important we got that out to councillors before you head away for a break. Just the February 14 submission date is challenging in terms of the calendar structure we'd set up at the start of next year for different briefings and workshops and council meetings, with the local government simplification due date being the 20th. So I'm going to have a chat with Amanda, Anita, and Hilary and Kevin first thing next week, just to look at that calendar, and we'll make sure we get some communication out to everyone before everyone sort of switches off end of day Tuesday or Wednesday next week. But no, nothing further from me. Still a lot of, obviously, a huge number of gaps to fill in, but a lot of different people working on it around the sector and other councils and LGNZ and others. So we'll keep sharing stuff as it comes through.
Awesome. Well, thank you all for giving us this time, and we'll be in touch. And otherwise, have a nice break, and we'll see you in the new year. Thanks all.
Cheers, Anita. Thanks, team.
Thank you.
Thank you, team.